Okay, I found this 5-page document about dealing with police, judges, etc., courts, bills you might get in the mail. It's called Rudiments of the System. Basis of action when confronted. Never walk into the police station or court voluntarily. If you do, you traverse and acknowledge the validity of their jurisdiction offer. As Lao-tzu noted 2,500 years ago, do not invite the fight, accept it instead. Better a foot behind than an inch too far ahead. Let the offer come to you, don't make the offer. When you are confronted with an obligatory court appearance, keep in mind the following. Everything is commerce/contract, being administered in a state of emergency under war powers. The Commerce Clause of the Constitution operates in the private international law merchant of the bankers, to whom essentially every government in the world is bankrupt. All of this functions in admiralty maritime, where you have no rights and the captain's word is law. As a result of the above condition, military war powers enforce all interstate commerce, which is everything, with draconian penalties for impeding commerce. Because the climate in which we live is a relentless and ravenous assault from all aspects of the government against our commercial liability, enforced by guns, violence, and prisons, life in America, a high-risk venture. It requires understanding of how to neutralize the endless barrage of attacks in the form of commercial presentments offers. Fighting is a no-win proposition. Matters must be neutralized, diffused, and transmuted into victory without conflict. We have no money, only private debt papers, insurance script like monopoly money or casino chips, which a real monopoly has foisted on the world, operating in the bankruptcy. Everything is commerce, which is banking, which is a debt paper, which is credit debt balances on bank books, which is bookkeeping. Assets, credits must always equal liabilities, debts. The books must always balance for the world commerce to operate. The commercial amount must be cleared within 3 days, which is codified in the U.S. in Federal Truth in Lending Act, Title 12, U.S.C. Section 1601, Regulation Z. A traffic citation, summons, indictment, complaint, etc. is a commercial presentment. When the presentment is issued, a debt is created, a liability on the bank's books, which must be balanced with an asset. They want you to supply the asset in form of paying a fine, some specific performance, or jail time. Every such commercial presentment is an offer to contract, concerning which you have the following 5 options. 1. You can deny or fight the charges and thereby traverse and join the action, legitimize their cause of action, and lock yourself into their jurisdiction. This is a commercial dishonor. If you enter a plea, or the judge enters one for you, you have traversed. The only issue now is the facts. Did you or did you not run the red light? In other words, dishonor submits you to a court proceeding to resolve the dispute over facts of the matter. 2. You can demur. A demur accepts all alleged facts as true and raises of issues of law. A classic example is, yes, I did it, but so what? The statute of limitations has expired, so issues of law foreclose all possibility for me to be prosecuted in this matter. 3, you can stand mute, in which the law and the facts are invoked. The judge will enter a plea for you, and a court proceeding to resolve the controversy will commence. Standing mute is also a commercial dishonor and locks you into both law and facts. 4, you can protest, such as denying jurisdiction. This also locks you into the requirement to proceed with the court process to resolve the dispute. 5, you can accept the offer, charges, citation, summons, complaint, indictment, etc. for value. Of the 5 options, only number 5 will diffuse, dissolve the controversy, thereby obviating all necessity or possibility for court proceedings, since there is no dispute to resolve. You have agreed with your adversary quickly while you are on the way with him. 2, makes you the owner of the contract/offer. 3, makes you the creditor. The creditor is always the winner in court proceedings, all of which have only 2 classes of participants, creditors and debtors. The debtor always loses and pays. After you accept for value and own the contract/offer, the matter is non-negotiable, private and personal between you and the offerer in his non-official capacity. Every arrest and incarceration today is seized and the surety of a commercial dishonor. The commercial accounts must balance for the commerce to function. It is not possible to retain only the debt side of a bank ledger. The offsetting asset side must be there for the books to balance, the commercial account to clear. Otherwise, world commerce would collapse into a pile of mush immediately. When you dishonor a commercial presentment, citation, etc., the offerer accepts your dishonor, undertaking a banker's acceptance and executing a bill of exchange. This bill of exchange is for at least 10 times the face amount, possibly 100 times. The one who accepts, being the creditor, is entitled to place whatever value he wishes on the transaction. The counties run on these bonds. You must now pay full amount or the bill of exchange, the bond, or the account remains open indefinitely. The case, the books never close. If you fail to pay in Federal Reserve notes to balance the books, then you are arrested and incarcerated as a surety, collateral to raise the funds to balance the ledger. These funds are raised by borrowing via your straw man on the public debt for which you, the real being, are responsible for paying. If you have not rebutted the rebuttable presumption that the king, wizards, bankers, power elite, etc., owns your all capital letter name, you have no liability in the books if the books are fully balanced. Performance on acceptance balances the books. This is one reason the prisons are full. Another reason is that the judges are part owners of the prisons and make money on everyone they incarcerate. Prisons are immense money-making operations due to the bonds raised against the straw men or debtors of the people, collateral, warehoused behind bars. High dollar amounts are attached to the bonds raised to incarcerate the people. The prison industry is big business, constituting a major industry in California, Texas, and Florida. If you have a bail bond, you can't proceed until you get rid of the bond, accept it for value, send it back to the bondsman, register the bond in the commercial registry as your secured property. Never confess who you are. That is bearing false witness against yourself. Some people advocate carry no identification. If you are arrested, they have 2 hours to identify you. If you identify yourself, They are allowed to hold you, provided you don't sign their paperwork or otherwise traverse, for 3 days or 72 hours. The general rule is, therefore, of course, never tell them who you are, why do their job for them, or sign anything. Anything you do except comply insofar as dealing with the police is concerned is interfering with a policeman in his line of duty. What is his duty? It is revenue collection for the city. One of 3 things is needed to identify you: your date of birth, the day your vessel or body was birthed into the 14th Amendment public charitable trust as a citizen of the United States, a corporate franchise launched into a voyage in commerce in an ocean of insolvency, unpayable bankruptcy, which is interesting because they're charging something that they own, which is your birth certificate. So they're charging themselves. Number 2, your driver's license. 3, your social security number. Without any of the above 3 items, their job is difficult to impossible, especially with the 2-hour time limit. A judge's job is to get you to traverse contest and dishonor, and thereby make an offer which the judge can accept and thereby own. If you are hauled into court or forced to go under threat, do not offer and do not negotiate. If you reject, negotiate, or issue a counteroffer, you create a controversy. You perform a dishonor which the judge can accept. Concerning every offer a judge makes to you, accept it for value with such words as, "Thank you for your offer, which I accept for value. May I have your name, please?" You are acknowledging his commercial resentment and wanting to know with whom you are doing business with and entering into contract. Therefore, you must proceed with the remainder of the standard questions and request. Do you have a claim against me? Do you know anyone who has a claim against me? I request the order of the court to be released to me immediately. If the judge says, "I don't have a claim against you, but I believe the prosecutor does," you proceed with the 3 questions to the prosecutor. If he says that the state of California, United States, etc., has a claim against you, say, "I call the state of California to the witness stand." When the state of California fails to take the stand to testify and be cross-examined, you can say, "It appears no one has a claim against me. I request the order of the court to be released to me immediately." Remember that when you accept their offer for value, you place the amount of the transaction and they are required to perform and adjust your account. You are now the secured party. Creditor, you are the principal, and the interest goes to you. Proof of claim. The fundamental issues must be perpetually kept in mind and actualized. Namely, the central core of any dispute is who can state the claim upon which relief can be granted. Whoever can prove his claim wins. One rebuts their rebuttable assumption of holding a claim against you via presumption of ownership of your birth certificate and straw man by filing a UCC-1 financing statement with the real you, upper and lowercase spelling of your name as secured party, and your name in all capital letters as the debtor. The UCC-1 is the single most irrefutable, unbreakable bedrock contract in the world today. Without rebutting their rebuttable presumption via filing a UCC-1, their unrebutted presumption stands as truth in commerce, and you have no standing in law. You are bereft of rights, devoid of standing in law, and completely unable to state a claim upon which relief can be granted. The result is that you are rendered permanent debtor owned by them, and concerning which they have carte blanche to deal as they wish. You are a slave on the master's slave plantation without capacity to go against your owner. Your filing of the UCC-1, you have irrefutable proof of your supreme claim, and if you proceed correctly, win in any proceeding as the acknowledged creditor in the matter, then all would-be claimants lose for failure to state a claim upon which relief can be granted. The bottom line is therefore, how do you state your claim upon which relief can be granted in a manner that cannot be ignored by a judge or administrative agency? The catch-22 of the matter is that in law only the original counts, but if you surrender your original of something, you no longer have it. Then, if the opposition confiscates it, you are devoid of a way to prove your claim and lose. This conundrum is resolved in the following manner. Obtain certified true copies of your UCC filings in the commercial registry that establish your basic claim on your straw man, and also any matter at hand, citation, indictment, course, case, etc. Take the above referenced documents plus a certified true copy of the court docket sheet, signed, dated, and stamped by the clerk pertaining to your case, if one exists, to a notary, and have 2 or more notarial acknowledgments of the entire package as a certified true copy of the original. Serve one of the original notary acknowledgments via process server or means such as registered mail with affidavit of service executed by a third party, notarized on the judge, designated as name of judge, upper and lowercase spelling, name of judge, full name of court, if such exists, or the legal department of or party that receives service of process, an agency. A notary acknowledgement has powerful effects and ramifications. It must be entered as evidence on the record of a court case, and a judge must take judicial notice of it. To achieve either of these results is not always easy. By proceeding in this manner, you have placed before the judge or authorized party on the other side a proof of your supreme claim that must be recognized and cannot be avoided. In short, you have stated on the record proof of your claim upon which relief can be granted. A mere copy of documents otherwise proving your supreme claim not only can be disregarded by a judge or a legal department of an agency, it may be mandated to be disregarded, considered hearsay, since only the original counts. To rely on mere copies may render your situation worse, since you have played your hand, tipped them off without the clout to back it up. If you or someone you know is in jail, have the central documents pertaining to the case notarially acknowledged and served on the judge with at least a statement to the effect enclosed attached herewith is a notarial acknowledged certified true copy of the documents substantiating the supreme claim, the citation, tax bill, complaint, case, etc. of name of secured party, either provide proof of claim superior to the claim of secured party as evidenced by the enclosed attached within, or your failure to prove and claim within said time frame constitute conclusive presumption, fact, judicial or administrative re judica. That no such claim exists. Absent your proof of superior claim, secured party requests that the account be adjusted and the order of the court be released to secured party immediately. Concerning anything you receive in writing from the system, it is demanded on or at least bears on your commercial liability. A document you receive is almost always a bill, commercial presentment offered to contract into you're paying a debt or engaging in some specific performance. In short, the system wants something from you. Otherwise, why would they send you anything? If it's a notice of discharge of an obligation, it is still a matter concerning which you must establish your superior claim by accepting for value and registering in your UCC on the commercial registry. As a result of the above, the procedure for dealing with essentially any document you receive is the same. Make copies of the presentment, keep the original intact, pristine, in a safe place, stamp a copy with text to the effect, accepted for value, all related endorsements front and back in accordance with House Joint Resolutions 192 of June 5th, 1933. Sign your name and date the stamped copy using blue ink. Send the stamped, signed, dated copy back to the sender within 10 days of your receipt thereof. By engaging in the above process, you have undertaken a banker's acceptance, become the owner of the contract and entire matter, the holder in due course, secured party, and creditor. You have placed the ball in their court, and their only options are to withdraw their offer within the 72-hour Regulation Z grace period, or thereafter be foreclosed from the options to do so. They are then stuck with the debt in the amount you are unilaterally choose, which must be at least equal to the amount of the bill, and preferably 100 times that amount to cover the bonding. Their failure to cancel the matter within 3 days is a commercial dishonor, and they are on the defensive. Make the above described procedure your norm for dealing with all unwanted claims against your commercial liability, whether tax agencies, bill collectors, court judgments, etc. Remember the central commercial maxim: an unrebutted affidavit claim or charge stands as the truth in commerce. You must accept for value and do so within the time frame of 10 days allotted to you in order not to waive your opportunity to do so.